In this session, we're going to cover legal vocabulary terms that every law student must know. So follow along with this illustrated guide, and we're going to go through the basic steps of what happens in a civil and criminal lawsuit so that you're aware of these steps and the vocabulary terms that go along with them. So we're going to start with a civil case. In a civil case, the defendant does something that the plaintiff does not like. So in that first drawing, the defendant breached a contract with the plaintiff and the plaintiff is unhappy. The plaintiff is the one suing. You can think of it as the plaintiff is the one complaining and the defendant is the one defending themselves in a lawsuit. So the plaintiff will have to decide to file a lawsuit in state court or federal court. Most lawsuits are brought in state court. So typical family law lawsuits, contract law, crim law, tort law, property law, all of these types of lawsuits are filed in state court. Federal court will hear some cases. So they'll hear cases based on the Constitution, for example, First Amendment free speech claims, or federal law, or in some cases if the parties are from different states and they're fighting over a large amount of money, over $75,000. And you'll get more into the nuances of this in your civil procedure class, but that's the basic thing that you should know. The plaintiff will begin a lawsuit by filing a complaint in the appropriate court. After filing the complaint, the plaintiff will have a certain amount of time to serve the complaint on the defendant. So basically, the plaintiff will first file a complaint with different counts. So for example, let's say that an employee is supposed to be paid by their employer and the employer does not pay them. The different counts might be breach of contract, fraud, different employment law claims. So they will file this complaint in the court. This tells the court that the plaintiff is going to sue or is suing the defendant. After filing the complaint with the court, the plaintiff has to let the defendant know that they're being sued. So the way to do this is to serve the defendant, either by mail or by hiring a process server to do it. But basically, serving is just a fancy way of saying you're giving the defendant notice that you are suing them. So the defendant will then answer the complaint. The defendant can admit, deny, or say he doesn't know how to respond to the paragraphs in the plaintiff's complaint. But basically, the defendant is required to provide some kind of response to the plaintiff's complaint. Next, discovery begins. So this is when information is being discovered. The United States has a very open door policy for discovery, and a lot of information can be discovered prior to trial. So the plaintiff can send, or the defendant can send, interrogatories. This is a fancy way to say questions. Is it true that blah, 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 blah? Request to admit. Please admit that you agreed to pay me $10 an hour to do X, Y, Z. Request to produce. Please produce the contract that we initially signed. Okay, so all of these can be sent to the other side. Also, sometimes depositions are taken during discovery. This is just a fancy way of saying that one party will ask questions to another party or a witness, and the witness has to answer those questions under oath. Sometimes during this process, a motion will be filed in court. If the case does not settle, and most cases settle, by and large, a lot of cases will settle, but if the case does not settle, then it will go to trial. The trial can be in front of a jury, this is called a jury trial, or just in front of a judge, which is called a bench trial. Both sides can call witnesses to testify. Testify just means to speak under oath in court. The burden of proof is on the plaintiff to prove her case by a preponderance of the evidence in most cases. So think of this as being over 50%. So as long as the plaintiff can show that it's at least more likely that her version of the story is true, the plaintiff will prevail. If they cannot show that, then they will not prevail. They will lose. A jury will reach a verdict, or a judge will reach a decision and issue a judgment. So the verdict is basically like who wins, and the judgment is, okay, how much money do you win, if you win any at all? For criminal and civil cases, sometimes the court will write an opinion, which basically says why the case turned out the way that it did, and that's the rationale. Courts usually cite precedent, which is binding law. Remember that lower courts have to follow the law as interpreted by higher courts. So for example, if the Supreme Court of the United States says something, they're the highest court in the United States. So all the other lower courts have to follow what they say. And this is true for any court. Any court that is above the court making the decision, that court has to follow whatever the higher court said. Rules of law come from the Constitution, for example, the U.S. Constitution or a state constitution. They come from case law or common law. This is created by judges when there is no controlling law. So most of what you read in law school will be case law. You'll be reading contract cases, tort cases, where basically the judge just makes up the rule of law based on what makes sense to them, and then it becomes controlling law. And lastly, rules of law come from statutes. These are express statements of law written by the legislature. The party that is unhappy with the decision can appeal it. So there is an appellate system at both the state and federal court level. I'm going to kind of simplify it because every state has their own system and their own terminology, but I'm going to tell you generally how the appellate system works. First, the case will be heard by the lowest court. This is the trial court or the district court. Generally, just one judge hears the case and they render a decision. The party who loses, or any party who is unhappy with that decision, can appeal it. This is the middle court, the Court of Appeals, or the appellate court. Generally, 3 judges will listen to what that party has to say, and if a party is unhappy with what the appellate court decides, then they can appeal it up to the Supreme Court. This is the highest court of the land. There are 9 justices in the United States Supreme Court. The reviewing court is usually bound by the facts that the lower court found, but can decide areas of law. So basically what this means is the reviewing court is not going to rehear all of the evidence. Whatever the lower court found in terms of the facts, this is what happened, the reviewing court will accept is true. Instead, they're just going to look at how the law was applied to the facts. And they'll do 1 or 2 of 3 things. They could affirm the lower court's decision, basically say, yep, you are right, lower court, we agree with you. So affirm is just a fancy way to say, we agree with you. They could reverse the lower court's decision by coming to the opposite conclusion as the lower court, or they can remand the case back to the lower court and tell the court, hey, you need to decide X, Y, Z. You need to tell me what the facts are on X, Y, Z. So remand is just a fancy way to say send back. Sometimes the court will write an opinion to say why it decided the way that it did. Sometimes the opinion will include a concurrence or dissent along with a majority opinion. So the majority opinion is the opinion that is agreed to by the majority of the judges. So this is like, okay, let's say 5 out of 9 judges agree with this. That's the majority opinion. The concurrence agrees with the outcome, so they concur in the outcome, but they don't necessarily follow the rationale of the majority. They say, yes, the case should have turned out this way, but for a different reason than you said. And lastly, the dissent disagrees with both the outcome and the rationale. They say, nope, this case should not have turned out this way at all, and this is why. So that's just a general overview of the civil justice system. Next, let's talk about an overview of the criminal justice system. So for a criminal justice system, we also have a defendant. The defendant does something illegal, and he is then arrested by the police. With a defendant, instead of having a plaintiff that is suing them in civil court, we have a prosecutor that brings a charge, sometimes called an indictment, against the defendant. The charge can be for a felony or a misdemeanor. Obviously, a felony is more serious than a misdemeanor. The prosecutor has to prove the elements of a crime beyond a reasonable doubt. This is a higher standard than the standard for civil cases because more than just money is at stake. Here, it's the defendant's liberty and maybe even life that's at stake. So therefore, the prosecutor has to prove beyond a reasonable doubt that the defendant committed the crime. Virtually every crime includes 2 elements, a guilty act, also called an actus reus, and a guilty mind, also called a mens rea. So basically, the defendant has to do something, and he also has to have a bad mindset while doing it. For example, obviously, if the defendant walked up to somebody and intentionally shot them in the head, that's a guilty act of killing someone, and he did so with a guilty mindset. He did it intentionally. But compare that to somebody who's driving very, very carefully. All of a sudden, a pedestrian comes out of nowhere and walks in front of them, and then that pedestrian is unfortunately killed. Well, the defendant did a guilty act technically because he, hit and killed the pedestrian, but the defendant did not have a guilty mind. He wasn't acting intentionally, recklessly, or negligently. It was just an honest accident and caused maybe by the pedestrian or just caused by bad circumstances, but not the defendant's guilty mind. So in order to be guilty of a crime, you need both a guilty act and a guilty mind. In most cases, instead of going to trial, the defendant will agree to a plea bargain where the defendant and the prosecutor come to an agreement. This is the typical way that most criminal cases resolve. I think something like 95% of cases are settled with a plea bargain. Alternatively, the case will go to trial where the defendant will either be convicted, so found guilty, or acquitted, so basically found innocent of the crime. So that's just a general overview of how the criminal justice system works. Hopefully this helps you as you come across this vocabulary in your criminal law class and in this pre-law course.